this is Olu Ogidon, and you're listening to UC3P.
Welcome to the University of Chicago Public Policy Podcasts. This is UC3P, our eponymously named podcast on policy, politics, and current affairs. My name is David Raban, and I'm the production manager for what we like to call the main page. Today, we talk with Lauren Sampson, a civil rights attorney who focuses on impact litigation. She works for a nonprofit, Lawyers for Civil Rights. They've done work on immigrants' rights, economic justice, and police accountability. We spoke with her about her recent work in education equity, climate justice, and other civil rights issues. Before we get into the interview, I have two notes. First, we apologize for getting this interview to you later than expected. We experienced some technical difficulties during our call, and then Thanksgiving and finals got in our way. Second, because of those technical difficulties, we wanted to let you know that we re-recorded the questions that we asked. The questions are exactly the same, but hopefully the effort makes this a better listen. Now, without further ado, here's civil rights attorney Lauren Sampson.
Welcome, everyone. Welcome, listeners. This is Irene SanPietro with UC3P. Today, we have with us Lauren Sampson of Lawyers for Civil Rights. I had the privilege of working with Lawyers for Civil Rights last year, and today we will be talking to Lauren about her current work as well as larger issues and dynamics in the civil rights and impact litigation space. Lauren, we're so lucky to have you. Thanks for being with us.
Thank you very much for having me, Irene. I should mention as well that Irene actually worked for Lawyers for Civil Rights last year and did an amazing job here. So she is very much a part of that work.
You're too much. Thank you. Well, as you know, this is a public policy podcast, and your work is in impact litigation. I think that our listeners won't necessarily know what that is. Can you tell us what impact litigation is and how is it different from private practice or legal aid?
Many times as an attorney, your focus is very much on an individual client and helping an individual client vindicate their rights or right some kind of wrong with the legal system. So, for example, if you work in legal services and a client comes to you and says, I've been evicted, you're helping that client navigate that process. Maybe you're identifying flaws with how that client was evicted. Maybe you're trying to make sure that you get the maximum they can. But really, your focus is on that individual client. With impact litigation, the focus is more on trying to change the law. So an individual client is really important, but they're also a stand-in for a much larger population that's being treated poorly by our legal system. So cases like Brown v. Board of Education or Hollingsworth v. Perry, US v. Windsor, like these are all examples of impact litigation cases where the plaintiff was extremely important, but with the bigger focus was on trying to change a scheme of laws in the country, in the state, or in the city.
There are those who think that lawyering is about applying the law and that judging is about refereeing the law. What would you say to our listeners who find it strange or surprising that lawyers work to actually change the law?
I think that the easiest explanation is that our law hasn't possibly conceived of every new problem or issue that's arising. And so we need law to be flexible enough to engage with the situations that we find ourselves in. The Constitution is one of the oldest documents in the United States. It's not possible that it could have foreseen things like the rise of digital privacy concerns or surveillance technology. Yet we need to be able to apply those principles in order to think about what kind of rights we have on the internet. And so as attorneys, when we're asking judges to think about changing the law, usually what we're doing is we're measuring the law against some other kind of standard, usually the Constitution, and saying it's not so much that we want you to change the law per se, it's that we want the law to match what the Constitution requires, even if it's not a situation the Constitution itself could have conceived of.
So in a way, it's holding us to our own values in a particular case.
Absolutely. There's actually something I think very conservative about saying that the document we need to abide by is one of our oldest, one of our truest, one of our most profound.
Lawyers for Civil Rights has the motto that laws are not enough. And I think that follows nicely on this discussion. Can you give us a sense of what LCR is as an organization and what the work is that you do, broadly speaking?
We are a nonprofit impact litigation organization that's been around for over 50 years. We were founded at the height of the civil rights movement at the request of President John F. Kennedy, and a number of lawyers responded to the call to action by his brother, the Attorney General, Robert F. Kennedy, and we continue that work to this day. We talk about the fact that laws are not enough because for Lawyers for Civil Rights, we see the ways in which the mere presence of, for example, an anti-discrimination law doesn't stop someone from being fired because of their race, or doesn't stop someone being mistreated in the workplace. The mere presence of that law on the books isn't sufficient. What you need are advocates, allies, fighters, people who can stand up and say, this law exists to protect our most vulnerable people, and we will champion their causes. I think a great example of this is as the Me Too movement reached its ascendancy, we noted that a lot of the folks being represented in the media were not the women who are so often targeted for sexual harassment, low-wage workers, women of color, immigrants, people who are largely powerless to stand back. And so we made that a real focus of our employment discrimination litigation because we wanted to amplify those voices and ensure that those women knew that the laws on the books protected them as well.
It sounds like there's a lot of work that comes before litigation, and I know that working with LCR, that your tools include policy advocacy, community education, and litigation. Why do you need all of them, and how do they relate to each other?
We think of ourselves at LCR as community lawyers, kind of a general counsel for low-income people, for immigrants, for people of color. And what that means is we follow the community's lead in deciding what kind of cases to bring. We look to them to tell us that a particular issue is bubbling up in their community, or that a particular employer or police officer or agency is acting discriminatorily. And then we respond to that. But part of that is ensuring that the community comes along with us, that when we file impact litigation, the community sees itself reflected in that lawsuit. And so before we do any filing, we have community meetings, we do interviews, we go on all kinds of media to make sure, one, that people know what's going on, but also to make sure we have the chance to tailor the litigation to the particular needs of the groups we're trying to serve. A good example, I think, of this is our Lowell voting rights case. We recently had a very successful settlement of a long-standing Voting Rights Act case against the city of Lowell, which was electing all of its city councilors and all of its school committee members at large, which meant that the very large minority population, coming to almost 49% of the city of Lowell, had no representation on either body. And we challenged that under the Voting Rights Act. And as part of our settlement, we didn't just implement a new voting system for Lowell. We actually put it to the community. So our attorneys, along with a number of other advocates, did a lot of community trainings and presentations. We had a video made in 3 languages that spoke to the community about how the voting system had worked, what the new proposed voting systems were, and what the pros and cons of each were, and then actually let the community decide what new system it would implement.
That sounds like a very robust life cycle of an intervention. So I want to turn to your work more specifically. You've been working on a case, and I hope I'm pronouncing this correctly, Musot versus Pazer. Is that correct?
Musot, yeah.
Musot versus Pazer.
Mm-hmm.
What's it about? What's at stake?
This case has been a long time coming. It is a school funding case, similar to those filed in other states across the country, especially places like Kansas, charging that the Commonwealth of Massachusetts is using an out-of-date and discriminatory formula for allocating funding to school districts across the state. So after a number of lawsuits brought earlier, including 2 particular ones in the 1990s and in 2005, the Commonwealth had adapted this formula by which it provides the bulk of school funding to different communities based on a formula where that looks at the number of students, the number of English language learners, the number of students with disabilities, the cost of health insurance for teachers, and uses all that information to generate a number. And it provides that to school districts, and school districts are responsible for the other 13%, basically, of what they think. The state has decided this is what we think your budget should be. We'll give you 87%. You should come up with the other 13. But for low-income school districts that have a lot of children of color, a lot of immigrants, they typically can't really pay anything more than that 13%. So they're at what we call about 100% of the foundation budget, at about exactly where the state projected they would be. Whereas wealthier school districts can afford to pay a lot more. And so as a result, the amount of money that's being spent on a child's education varies drastically depending on what community you find yourself in, veering from, $18,000, $19,000, $20,000 in Watertown to about $13,000 in Chelsea. And the difference between those is staggering. You see kids in Chelsea that are like 30, 40 kids to a classroom. If a teacher is out sick, they just kind of cram everyone into the gym or an auditorium. There are few electives. There are very few school counselors. There's a really heavy reliance on discipline and out-of-school discipline rather than restorative justice or other kinds of measures. And you see teachers on platforms like Donors Choose requesting really basic school supplies like paper or pens or ink because there just isn't money to cover anything. So we filed a lawsuit saying that this violates the Massachusetts Constitution, which includes within it a duty to cherish public education. That is to provide funding for an adequate education to make sure that all children have the ability to succeed. And we filed this on behalf of parents and children in several school districts across the Commonwealth, as well as two community groups, the NAACP and the Chelsea Collaborative, to argue that this violates the fundamental right to education, this violates the obligation to cherish education, and that this is racially discriminatory.
It's interesting that you chose to use state provisions and the state constitution to tackle this problem. What do you consider when deciding whether to bring a federal or a state claim, or some combination of the two?
We think about a lot of different things ranging from the kind of law that would be controlling. So in this instance, the controlling law would be, we think, these solid decisions from the Massachusetts Supreme Judicial Court that make really clear what the obligation to cherish public education means. We also have a case from a few years ago that Lawyers for Civil Rights was involved in, involving the cap on charter schools, that also had powerful language about the right to an education and the obligations upon the state. So that's certainly one consideration, thinking about the law that's controlling. You also want to think about what exactly the actual state law provision is. I think, when you're in law school, you think a lot about federal law. You're taught a lot with a focus on the federal Constitution. But the Massachusetts Constitution is actually older than the U.S. Constitution. And especially in this respect, we think it's a lot more robust. And its provisions can be used as a means of really strengthening the obligation of the state. Two, if a case terminates at the Massachusetts Supreme Judicial Court based on the Massachusetts Constitution, it can't be appealed to the Supreme Court. The Massachusetts Supreme Judicial Court is the expert and final authority and final word on our Constitution. So it means that if we have a court that is considering its own interpretation of the law and rendering a decision on that without having to involve any other federal decision makers.
And there's certainly an efficiency to that. But at the same time, it sounds like there could be a cost in terms of siloing or limiting the precedential value of the outcome.
Absolutely. And I think that's certainly something that we've seen in other states. Is in school funding cases, there's sometimes a reluctance by advocates to interpolate the lessons from, say, Kansas, because it's based on the Kansas Constitution and on rulings of Kansas state courts. But I think that sometimes one of the costs that you weigh when engaging in decision of where exactly to bring litigation, who will this benefit? And we think in this case, given the strength of this constitutional provision in the previous law, it just makes the most sense for the plaintiffs in this case, as well as all children in Massachusetts who we hope are benefited by a declaration from the court.
As China's role grows greater on the global stage, you want to stay up to date on the issues most pressing to China both domestically and internationally. Check out the Just China podcast for in-depth analysis on recent headlines and investigative reports on Chinese matters that affect our globalized world. We are Just China. Find us on Apple, Spotify, or wherever you enjoy your podcast listening.
I want to pivot here because at the same time that LCR is working locally, you also just started a global initiative on race and climate justice. We tend to think of this as a problem happening elsewhere, in low-lying areas, for example. What do race and climate justice mean for an American city like Boston?
There's a couple ways I want to answer that. So the first is thinking about migration. Boston is home to a lot of folks who hold statuses like TPS, temporary protected status, who came